In a move that comes as no surprise to the fine fella in the fedora, the Biden administration has decided to appeal Judge Doughty's decision that was handed down on July 4th that restricts the Biden administration's ability to be in contact with social media firms such as Twitter, YouTube, Facebook, etc., except and only for limited circumstances. So, what does the appeal go to? What is the reaction of the media to the judge's initial ruling? And where is all this going to wind up? Hang on, folks. We're going to get into all that in just 1 second. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. In a move that comes as no surprise to myself or others who've been keeping an eye on this situation, the Biden administration announced today that it intends to appeal Judge Terry Doughty's decision that was handed down yesterday regarding the limiting of the executive branch on contacting social media platforms like Twitter, YouTube, Facebook, and others to make sure that they cannot censor or throttle free speech. Now, what's interesting about all this is how fast the appeal is coming down, the reaction of the media, and other things that are happening. So let's start with our first article. We're going to take a look at an article that just popped up from Politico.com. Take a look at this. Headline: Government appeals ruling that restricts feds from contacting social media firms. The unusual July 4th ruling found that the Biden administration's contacts with web platforms amounted to censorship. Article written by Josh Gerstein. The Biden administration is appealing a court ruling sharply limiting the ability of the federal officials to interact with social media companies about the content contained on their platforms. In addition, a Justice Department official said Wednesday night that attorneys there plan to act expeditiously to stay the unusual injunction issued on July 4th by U.S. District Judge Terry Doughty in response to a lawsuit filed by Louisiana and Missouri last year. The suit claims that President Joe Biden's White House, the Department of Health and Human Services, and officials at other agencies committed censorship in violation of the First Amendment by pressuring social media companies to remove or limit access to anti-vaccine posts and to take down the accounts of certain users. Now, for those of you who may not be familiar with what's been going on, over the past couple or 3 years, many people have felt that when they would post something online, doesn't matter what the social media platform, and in some cases it doesn't necessarily matter the subject. It might be related to COVID, it might be related to alternative treatments for COVID, it might be related to the 2020 election, the Hunter Biden laptop story, whatever. That whenever they would post something on social media, either the reach of their post would be throttled, or in some cases suppressed, or in some cases just taken down altogether. Now, conservatives and libertarians had that suspicion for the longest time until journalists like Matt Taibbi and Michael Schellenberger were given access to Twitter's internal files and email systems by Elon Musk to show that it's not just a suspicion, it's largely true, and there is evidence to back it up. Proof of which, go back and look at their writings known as the Twitter files. Now, last year, two different attorney generals, one from Missouri and one from Louisiana, brought suit against the Biden administration. In March, it was the government attempted to have the lawsuit dismissed. Judge wouldn't allow it. Matter of fact, he moved it forward to discovery, where evidence could be obtained. Now it's reached the point where this judge, as of yesterday, issued an injunction which severely limits the Biden administration's ability to contact these social media companies and get them to suppress or take down certain posts. Now, as I say, not unexpectedly, the Biden administration is going to appeal this. What will happen next is this will go from Judge Doughty's court to the full Fifth Circuit, which is based out of New Orleans, Louisiana. Now, for those of you who don't know anything about the Fifth Circuit, let me put to you this way. It's sometimes said that people go judge shopping. In other words, they want to find a judge they think is going to be friendly to their cause. Well, you could make an argument that the same thing applies when it comes to finding what circuit you want to bring a federal case in. For example, the Ninth Circuit out on the West Coast is known as the liberals' paradise when it comes to judicial rulings that tend to lean to the left. If you want to get something done that favors your cause in that political persuasion, go out and get the Ninth Circuit involved. Well, the same thing can be said for judicial conservatives when it comes to the Fifth Circuit. The Fifth Circuit is widely regarded as one of the most, if not the most conservative judicial circuit among the federal bench. So it's going to be very, very interesting to see what happens when this gets down to New Orleans in the next few weeks and months. Now, where does all this go? Well, I think ultimately it's going to wind up in the hands of the Supreme Court. As I said in my video yesterday, there have been questions circling around now for some years about what exactly is the role of a social media platform vis-a-vis the First Amendment of the United States Constitution. Is the social media platform there just to provide a place where people can speak their mind in an open forum, or does the social media platform have a editorial responsibility to make sure that they are not promulgating or perpetuating or spreading misinformation, however you want to define that? The government has a very broad definition of what they think misinformation is. Cynically speaking, I would say they would define misinformation as anything they don't want talked about or anything they don't want you to know about. But that's just me. Now, the judge handed down his ruling yesterday in the form of an injunction. So what's been the practical effect? Well, believe it or not, it's taken hold very fast. Take a look at this. This is an article from the Washington Post. Headline: State Department cancels Facebook meetings after judge's censorship ruling. A Louisiana federal court order is upending efforts to guard against 2024 election interference. Let's take a look at this. Article written by Joseph Min, Will Ormeas, Kat Zakretsky, and Naomi Nix. We read the following. One day after a Louisiana federal judge sets limits on the Biden administration's communication with tech firms, the State Department canceled its regular meeting Wednesday with Facebook officials to discuss the 2024 election preparations and hacking threats, according to a person at the company. The move comes hours before Biden's Department of Justice filed a notice that it will appeal the ruling. Now, I want to stop for a second before we go further into this. Did you folks happen to catch what was written here? The State Department canceled its regular meeting Wednesday with Facebook officials to discuss the 2024 election preparations and hacking threats. Emphasis on the words regular meetings. Now you begin to understand why conservatives, libertarians, free speech advocates are getting very, very nervous about more and more regular conversations that are going on between the executive branch of the government and social media platforms that are supposed to be offering a place where people can freely express their opinions. This is the Washington Post admitting that the government is having regular meetings with Facebook. And people wonder why folks like us on the right are a little bit more than upset about this. But let's continue with the article. Moving on, State Department officials told Facebook that all future meetings, which had been held monthly, had been, quote, canceled pending further guidance, said the person, who spoke on the condition of anonymity to preserve working relationships. Quote, waiting to see if CISA cancels tomorrow, the person added, referring to the Department of Homeland Security's Cyber and Infrastructure Security Agency. The person at Facebook said they presumed Similar meetings the State Department had scheduled with other tech firms were also canceled, but that could not be confirmed immediately. Representatives for the State Department did not respond to a request for comment. CISA declined to comment, referring questions to the Justice Department. A Justice Department official declined to comment on the cancellations, but said the agency expects to request a stay of the district court's decision expeditiously. So Judge Doughty's decision is already having some serious effect. But I wonder what folks in the press think about the initial decision itself. Well, let's take a listen to that. Walter Isaacson, who used to be the head of CNN, especially back during the very dark days of 9/11, had this to say on MSNBC the other day. Take a listen to this.
And I think Judge Doughty's decision goes too far. We're in the press. We're always used to people from the government saying, hey, Twitter file showed, and in my book I talk about the night after night when they're releasing these files, is that it went a bit far. It wasn't just government saying, don't amplify things about, say, the talks about the spread of COVID. It was somehow coercing a bit. And what was worse, the social media companies didn't just play along, they colluded and tried to stop some of the flow of information. So I think this is a little bit of a corrective, but I clearly feel that in the end, the decision will be refined somewhat because government has to have the right to have its own free speech, to push back when they see things on social media they think are dangerous.
Okay, now hold it right there. I want to talk about something for a moment. I respect Isaacson's points up until he got to the end of this, that the government has to have its space to push back, its own form of free speech. Well, first of all, if you read through Judge Doughty's ruling, no one's denying that. As a matter of fact, the judge makes certain exceptions under which the government can contact these social media companies. As a matter of fact, let me pull those up real fast because I think this is very telling. This is on page 5 of his order. It is further ordered that the following actions are not prohibited by this preliminary injunction. Number 1, informing social media companies of postings involving criminal activity or criminal conspiracies. Number 2, contacting and or notifying social media companies of national security threats, extortion, or other threats posted on its platform. Number 3, contacting and or notifying social media companies about criminal efforts to suppress voting, to provide illegal campaign contributions, of cyber attacks against election infrastructure, or foreign attempts to influence elections. Number 4, informing social media companies of threats that threaten the public safety or security of the United States. Number 5, exercising permissible public government speech promoting government policies or views on matters of public concern. Number 6, informing social media companies of postings intending to mislead voters about voting requirements and procedures. Number 7, informing or communicating with social media companies in an effort to detect, prevent, or mitigate malicious cyber activity. And number 8, communicating with social media companies about deleting, removing, suppressing, or reducing posts on social media platforms that are not protected free speech by the Free Speech Clause in the First Amendment to the United States Constitution. Ladies and gentlemen, I don't know about you, but it sounds to me like the judge crafted a very even-handed ruling. He said, look, with the exception of these 8 things, federal government, more particularly the executive branch, you cannot be in contact with these social media companies. And the 8 things that are listed as the exceptions that the government can use to be in contact with these social media companies is actually, all things considered, pretty broad. And it deals with very certain and specific areas. I mean, for example, cybersecurity, national security, criminal activity, etc. These things you would expect the government to be involved with as far as reaching out to a social media company and saying, hey, we need to make you guys aware of something. This is going on. Be advised. Now, let's turn that coin around and look at the other side of it. Everybody in the press is all up in arms about, I can't believe the judges ruled this way. This is awful. The government has to be able to talk to social media companies. Why? For what? I mean, with the exception of the 8 items that I just read in the judge's injunction order, I have a question for all y'all out in the press. Why do you need to be in contact with a social media company? Now, if it's an issue that they themselves as a business are breaking the law, or you feel you need to investigate something about their business practices, okay, I could understand that in your law enforcement function. But absent that, or absent one of the 8 reasons that this judge has handed down, why do you need to be talking to them? Why do you need to be having conversations about upcoming elections? Why do you need to be having conversations about the suppressing of social media posts? And I will show you a piece of evidence here in just a moment that proves that this is one of the things that the government was doing. Food for thought. Now, I want to show you one more reaction from the press, and this one just blows my mind. CNN this morning. They're having a roundtable discussion, and the head of the panel asks Ellie Zoeg, who is the senior legal analyst, their opinion of the whole matter. Take a listen to this.
Appointed judge, but this judge was confirmed 98-0 by the Senate. Just reading the words in this injunction, a, quote, massive effort by the defendants to suppress speech based on content, those are the judge's words, calling the present case, quote, arguably involves the most massive attack against free speech in the United States history, Ellie.
Yeah. It's a dramatic decision by this judge. If you read through it, he's citing to literature and George Washington and Ben Franklin. Here's what really is astonishing to me. This is a conservative ideology that clearly comes through in this decision. It's a conservative political ideology, right? We saw some of the quotes questioning vaccines, questioning masks, conservative talking points. But the ruling itself is the opposite of judicial conservatism. This is one of the most aggressive, far-reaching rulings you'll ever see. What this judge is purporting to do is to micromanage, really, the day-to-day interactions between essentially the entire executive branch, all these agencies that are listed as defendants, and the leading social media companies. And in the actual temporary injunction, the judge basically says, you're not allowed, administration, to talk to these social media companies about any protected free speech except for cybersecurity threats, national security threats, criminal threats. But where's the line? Who's going to police this?
Okay, just a moment. The line is established in the injunction, Ellie. If you would have taken the time to read it, you would understand that here are the 8 reasons why the executive branch of the government of the United States is allowed to contact a social media platform. Absent that, you've got no legitimate reason to be doing it. There's your line. Now, the argument that says this is the most conservative activist ruling I've ever heard of. Number one, what the hell do you think's been going on for the past 50 or 60 years, buddy? I mean, do you honestly think that judicial rulings coming out of places like the Ninth Circuit and other places around the country that just reek of judicial liberalism are just somehow, everybody doesn't realize what they are? And furthermore, this is not a far-reaching ruling, sir. If anything, this is a full-throated defense of free speech and the right to exercise it. That's what you folks in the press don't understand. This judge has done more to stand up for the individual citizen's right to speak out on whatever matter they wish in a lawful, constitutional manner than anybody has done in a hell of a long time. I would argue going back to the 1960s. And by the way, my name might be the Front Porch Conservative, but even I give credit to liberal jurists on the Supreme Court back in the 60s who argued, hey, you may not like somebody's free speech, but daggone it, it's protected under the First Amendment. What this judge has done is begun to bring back into balance constitutional order on the question of the First Amendment and free speech, and you know what? I am here for it. Absolutely here for it. I said I'd show you one example of why this judge's order was needed. Take a look at this. This is from Matt Taibbi. This is from his Twitter page. Example of a direct request for censorship from the White House from the Missouri v. Biden case, here involving Robert Kennedy Jr. Who could look at this kind of thing and insist it's a, quote, nothing burger? Here's the email from an official at Twitter to Clark Humphrey, among other government individuals. Subject, flagging Hank Aaron misinformation. The email thread starts, and then if we can keep an eye out for tweets that fall in the same genre, that would be great. Next day, from this Clark Humphrey, wanted to flag the below tweet and am wondering if, quote, we can get moving on the process of having it removed ASAP. This official at Twitter replies, thanks, we have recently escalated this. This is a tweet from Robert Kennedy Jr., ladies and gentlemen. This official in the government is wanting it removed. So you folks out there in the press, don't you dare sit there and tell me that government is not trying to collude with big tech to stop free speech. Here's a perfect example of it. This is just one example of why that judge's order is probably one of the best reasons why this thing went down the way it did. But that's my opinion on it. What's yours? As we start to wrap this up, please do me some favors as always. Number 1, if you are not a subscriber to this channel, please do so. Number 2, please leave a comment below. Number 3, please share this with friends of yours who you think would enjoy this content and they themselves might want to subscribe to the channel. And number 4, please give me a thumbs up. My name is Brian Trippett. I am your front porch conservative, and I'll see you next time.